You're looking at the exact moment Judge Caldwell lost patience after the Witness 14 tape leaked this morning. The defense team didn't just lose an argument, they lost their freedom. Federal marshals walked 3 defense attorneys out in handcuffs in the middle of a trial. When a sitting federal judge orders the arrest of officers of the court in open session, something catastrophic has happened. So what triggered this unprecedented courtroom explosion? At 7:47 a.m. Eastern, an encrypted audio file appeared almost simultaneously on 4 major whistleblower platforms. The label was blunt: W14, privileged, do not distribute. Within 90 minutes, it had been downloaded more than 3 million times. By 9:15 a.m., the audio was playing on every major news network, dissected in real time by anchors, legal analysts, and former prosecutors. The recording was identified as Witness 14, the prosecution's star protected witness in a federal corruption case, speaking in a recorded conversation that was never supposed to exist. And according to prosecutors, the conversation wasn't just embarrassing. It was criminal. This isn't internet speculation dressed up as drama. This is the kind of leak that forces a courtroom to choose between procedure and survival. Judge Caldwell didn't call a recess. He didn't issue a warning. He didn't ask counsel to approach the bench. He signaled U.S. Marshals and ordered the defense table detained before the morning break. Court observers say that in 37 years on the federal bench, he has never done anything remotely like this. And the reason becomes clearer once you understand what prosecutors say was on that tape and what they placed in a sealed filing that landed on his desk moments before the arrests. The recording runs 11 minutes and 43 seconds. It captures a conversation among 3 individuals prosecutors identify as lead defense attorney Marcus Webb, associate counsel Daniel Harmon, and a third voice described in filings as an intermediary tied to the defendant's business associates. The first bombshell drops at the 2:14 mark. Webb's voice, steady and unmistakable in the clip circulating online, states, "The witness needs to understand that cooperation has consequences. Not legal consequences, personal ones. Make sure that message is received before Thursday." That line is being treated as a direct reference to Witness 14's scheduled testimony, and prosecutors characterize it as a threat, not a warning about perjury, not a reminder of legal exposure, but an instruction to deliver personal consequences. From there, the conversation allegedly moves into even more dangerous territory. According to prosecutors, Webb discusses details from sealed grand jury materials, names, dates, internal references, and context that would ordinarily be protected by strict secrecy rules. That alone can trigger sanctions, contempt, and a separate criminal inquiry, depending on how the information was obtained and shared. But the tape doesn't just describe knowledge. Prosecutors argue it describes a plan. At the 4:47 mark, the third voice responds. The family situation has been made clear to him. Wife's employer, the kid's school enrollment. He understands what's at stake. Read that slowly. It's not about impeaching credibility. It's not about negotiating testimony. It's family leverage, employment leverage, a child's school. Prosecutors characterize this as explicit witness tampering and obstruction of justice, pressure aimed not at lawful exposure, but at personal safety and stability. And if that wasn't enough, the tone of the conversation matters. It's not frantic. It's not speculative. It's matter of fact, like the pressure points were already mapped. The most damaging section for the defense may be the money. At 8:22, Harmon asks about payment arrangements. Webb replies, "The retainer covers this. It's been structured through the consulting LLC. Nothing traces back." That line doesn't sound like trial prep. It sounds like concealment. Court filings referenced in coverage today reportedly include subpoena activity and financial records showing wire transfers totaling $847,000 from an offshore entity linked to the defendant's former business partner. The transfers occurred on January 3rd, January 6th, and January 12th, dates that match the timeline referenced in the recording. Prosecutors argue this isn't just how retainers work. They argue it's a payment mechanism built to hide what the money was buying. The transcript keeps pushing. Around the 9:56 mark, Webb allegedly gives specific instructions on how to approach witness 14's brother-in-law, described as a contractor for a company that does business with the defendant's associates. Make it clear the contract renewals depend on reasonable behavior from the whole family, Webb says, according to the transcript. That is the language prosecutors point to when they argue this isn't a single impulsive comment. It's a coordinated scheme. Identify a pressure channel, apply pressure indirectly, and create consequences that never have to be said out loud in court. And then, in the final 90 seconds, the conversation reportedly turns to contingencies. What to do if witness 14 doesn't respond. Harman suggests making an example of a different witness in an unrelated case, so word gets around. Webb's response is the line legal analysts keep circling. That's being handled separately. Different team. If prosecutors can prove different team refers to a wider effort involving other lawyers, intermediaries, or targets, this case doesn't just stay inside one courtroom. It could expand into a broader conspiracy investigation, and that's why people keep whispering the same three letters, RICO. Within hours of the leak, federal investigators moved to authenticate what the public was already consuming at full speed. Court filings cite an FBI lead forensic audio analyst who was brought in within hours and who reportedly authenticated the recording. Prosecutors say voice pattern analysis matched Webb and Harman with 99.2% certainty. The metadata, according to those filings, indicates the recording was made on January 11th, 2026, just 5 days ago. If those claims hold up, then the tape isn't a decades-old scandal resurfacing. It's a fresh recording from inside an active defense operation in the middle of an ongoing federal trial. And here's the kicker prosecutors emphasize. The recording device wasn't planted by law enforcement. It was placed by someone inside the defense team's own circle. Court papers suggest a junior paralegal with access to Webb's office recorded the conversation. That paralegal's identity remains sealed, but filings indicate the person may have been cooperating with investigators for months. According to the same documents, the FBI opened a parallel investigation into the defense team on December 29th based on a confidential informant tip, and that the paralegal had been wearing a wire for roughly 3 weeks. If those allegations are true, this wasn't about aggressive lawyering. It was about a suspected criminal conspiracy operating from inside the courtroom. Former federal prosecutor Amanda Chin told MSNBC this afternoon that, based on what she reviewed, this represents one of the most brazen examples of witness intimidation she's seen documented because it blends threats, payment concealment, and alleged misuse of privileged access. Other analysts focused on how deliberate the language sounds. Consulting LLC. Nothing traces back. Family situation made clear. If you believe the transcript, they spoke like people who assumed they would never be held accountable because they were wearing suits and carrying bar cards. Now take a breath and zoom out, because the backstory makes today's arrests feel less like a lightning strike and more like the end of a fuse that's been burning for weeks. This trial began in late November 2025 as what appeared to be a straightforward federal corruption case. The defendant, real estate developer and political donor Victor Ashworth, faced charges of bribing local officials to secure zoning approvals and construction contracts worth hundreds of millions. Witness 14 was the prosecution's linchpin, a former Ashworth company executive who flipped after receiving a target letter and allegedly brought documentary evidence of cash payments, offshore accounts, and a network of shell companies used to funnel bribes. Tensions had been building for weeks. The defense filed aggressive motions to exclude key evidence and repeatedly attempted to unmask witness 14's identity. Prosecutors described what they saw as a campaign of legal harassment aimed at government witnesses, motions, subpoenas, and tactics designed to force disclosure by pressure rather than by law. Everything changed on January 6th when Judge Caldwell denied the defense's fourth motion to reveal witness 14's identity. In that ruling, he noted what he called increasingly concerning patterns in the defense's approach to protected witness issues. That denial matters because it frames what prosecutors allege came next, a pivot from litigation into coercion. According to court documents filed this morning, The FBI had already opened a parallel investigation into the defense team on December 29th, triggered by a confidential informant tip. The informant, filings suggest, was the same junior paralegal mentioned in relation to the recording. Prosecutors allege the paralegal recorded the now-leaked conversation on January 11th. Agents reviewed the audio quickly, but held off on arrests to gather additional evidence, financial records, corroborating communications, and any proof that pressure tactics were being executed, not merely discussed. Sources indicate prosecutors had planned a controlled disclosure in sealed proceedings later this week. The leak changed everything, forcing the government's hand in public and forcing the court's hand inside the courtroom. By mid-morning, the courtroom itself became the story. Observers say Marcus Webb, who founded his law firm 23 years ago and built a reputation representing high-profile white-collar defendants, sat motionless as marshals moved. Daniel Harmon, a former federal prosecutor who shifted to defense work in 2019, allegedly tried to address Judge Caldwell and was told to remain silent. The third attorney arrested, Junior Associate Priya Nakamura, appeared visibly shaken. Prosecutors have indicated she possessed knowledge of the scheme and failed to report it as required by law, though her specific involvement in the recorded conspiracy remains unclear based on public reporting. Then came the moment everyone in that courtroom will remember. At 10:47 a.m., Judge Caldwell received a sealed filing from prosecutors. Court observers describe him reviewing it for roughly 90 seconds, his face hardening with each page. Then he looked up and said one word, "Marshals." For U.S. Marshals stationed near the exits began moving toward the defense table. Webb rose to his feet and reportedly began, "Your Honor, I must object." Caldwell cut him off with a gavel strike so sharp reporters described it as sounding like a gunshot. "Mr. Webb, you will remain silent. You are being placed under arrest. Mr. Harmon, Ms. Nakamura, do not move. Do not speak." When Webb attempted to speak again, Caldwell's response became the line people are now quoting, "Counsel, I have reviewed the evidence of your criminal conspiracy to obstruct justice, tamper with a federal witness, and violate every oath you swore when you became an officer of this court. Your voice is no longer welcome in my courtroom. Marshals, proceed." Within 3 minutes, all three attorneys were in handcuffs. Victor Ashworth sat alone at the defense table as his legal team was walked out in custody. The symbolism was brutal. The defendant's right to counsel didn't vanish, but his counsel disappeared, and the court signaled that what it had just seen wasn't misconduct. It was alleged criminality. At that point, the corruption case became two cases: the trial itself, now suspended, and the new investigation into the defense team's alleged obstruction. This isn't the first time defense attorneys have faced arrest for conduct tied to a case. In the 1990s, prosecutors targeted lawyers who acted as house counsel for organized crime figures, attorneys accused of becoming participants in an enterprise rather than advocates operating within ethical bounds. Those prosecutions reinforced a principle still taught in every legal ethics course: attorney-client privilege does not protect lawyers who become co-conspirators. Then there was the 2008 case of prominent Texas defense attorney Stephen Crawford, disbarred and sentenced to 15 years after prosecutors proved he helped his client intimidate witnesses through coded messages during jail visits. But those cases, analysts note, often centered on one lawyer or a narrower channel. Here, the alleged conduct involves multiple attorneys, a third-party intermediary, and what looks like a payment structure designed to obscure the trail. More recently, in 2021, a defense attorney in Florida was removed from a murder trial after evidence emerged that she contacted a witness's employer. She faced disciplinary action and potential disbarment, not immediate federal prosecution, because the contact, while improper, didn't cross into explicit criminal threats. Analysts say the alleged Webb recording crosses that line repeatedly. The references to a spouse's job, a child's school enrollment, contract renewals, and making an example of another witness are why commentators keep describing it as a different category of conduct. Legal commentators are also struck by the apparent coordination. The tape's references to structured payments, a consulting LLC, offshore wiring, and different teams suggest planning. Former U.S. Attorney Jonathan Blackwell, who prosecuted white-collar cases in the Southern District of New York for 15 years, emphasized the recording's potential RICO implications. If prosecutors can show the different team reference points to additional intimidation campaigns and that a pattern of acts was coordinated to influence witnesses across cases, the theory expands from isolated obstruction into enterprise behavior. That shift would not just threaten 3 attorneys. It could pull in firm staff, intermediaries, and anyone involved in handling or routing payments. Former federal judge Richard Howell told CNN this afternoon, "In my entire career, I never saw anything like this." Defense attorneys threatening witnesses' families, discussing payoff structures, talking about making examples. This isn't aggressive advocacy. This is organized crime wearing a suit. That's a dramatic framing, but it captures the moral shock people are reacting to. Defense lawyering is supposed to be zealous. It is not supposed to be coercive. The system survives because defense counsel can fight hard inside the rules, and prosecutors can't claim foul every time they lose emotion. When lawyers allegedly step outside that framework and into intimidation, they don't just risk themselves, they endanger the integrity of the entire proceeding. Now the question becomes, what happens to Victor Ashworth's trial? His entire defense has been arrested. Every strategy, every motion, every cross-examination outline prepared by Webb's team is now presumptively tainted. The defendant didn't just lose his lawyers. He may have lost any chance at a clean trial record. Judge Caldwell has the mistrial motion under advisement. He has not ruled. But even if he denies mistrial, a pause is inevitable. Ashworth will need new counsel, and new counsel will need time to assess what was done, what can be used, and what must be rebuilt from scratch. This is where legal procedure gets complicated fast. Prosecutors have already indicated they may seek to use defense team communications as evidence against Ashworth himself, arguing that attorney-client privilege was forfeited when the attorneys allegedly became co-conspirators. That argument relies on the crime-fraud exception, a doctrine that allows otherwise privileged communications to be disclosed if they further a crime. If Judge Caldwell agrees with prosecutors, Ashworth faces a nightmare. His own legal team's words could become a weapon in the government's case against him. If Caldwell rejects the argument, prosecutors still have the tape, the financial records, and whatever their parallel investigation has gathered, and the defense still has to rebuild under intense scrutiny. Meanwhile, the Department of Justice appears to be expanding the investigation dramatically. Sources familiar with the matter told reporters this afternoon that a task force is being assembled to investigate what the tape calls different teams. FBI agents executed search warrants at Webb's law firm offices in Manhattan at approximately 2:30 p.m. today. Additional warrants are reportedly pending for satellite offices in Washington, D.C., Miami, and Los Angeles. Sources say the investigation now involves at least 18 agents and 3 separate federal prosecutorial teams. That matters because it suggests the government isn't just triaging one leak, it's looking for a network of conduct and a full map of who knew what, who did what, and where the money went. The witness protection implications are enormous, too. Witness 14's identity remains officially sealed, but the leak and the alleged threats mean the witness and the extended family now require emergency protection. Sources indicate the U.S. Marshals Service has initiated relocation procedures for multiple individuals connected to Witness 14. That's not a routine move. It's the system responding to a perceived credible risk. And if a protected witness is permanently silenced through fear, harm, or disappearance, the prosecution's case against Ashworth could collapse regardless of what happens to the defense attorneys, because you cannot try a case without witnesses willing and able to testify. The legal profession is also facing immediate consequences. Bar associations in New York, New Jersey, and the District of Columbia have announced emergency proceedings regarding Webb, Harmon, and Nakamura. Beyond disbarment, civil liability looms. Every client Webb's firm represented may now have grounds to sue for malpractice if they can argue representation was conflicted, compromised, or criminally tainted. Insurance carriers are reportedly reviewing exposure. Legal industry analysts estimate the firm could be bankrupt within months. And in a profession built on reputation and trust, the reputational collapse can outrun the legal process itself. Then the accused attorneys made the public narrative worse, at least in the immediate aftermath. Webb's personal attorney arrived at the federal detention facility and told reporters the case was politically motivated, designed to interfere with Webb's effective representation. He claimed the recording was taken completely out of context and said they would contest admissibility and authenticity. When asked about the FBI's voice authentication and metadata analysis, he declined to comment and rushed into the building. Harriman's spokesperson released a statement calling the situation a grave misunderstanding and claiming he always conducted himself with the highest ethical standards, without addressing the specific language cited from the tape. Legal ethics professor Amanda Chin criticized that approach publicly, arguing that out of context concedes the words were spoken while inauthentic, denies they were, and blending the two without confronting the substance looks like evasion. In criminal defense, you can dispute authenticity or you can explain conduct. Suggesting context while dodging specifics can land like an admission that the tape is real and that the defense doesn't have a clean explanation. Victor Ashworth has remained silent. His family issued a brief statement expressing complete confidence in his innocence and declining further comment. Meanwhile, Webb's law firm attempted to distance itself from the arrested partners, issuing a statement of shock and announcing an internal investigation. 3 named partners have reportedly resigned. Junior associates are said to be leaving for rival firms as quickly as possible. In white-collar practice, reputation is currency. When a firm's name becomes synonymous with witness tampering allegations, the exits happen fast. So where does this leave the system itself? Defense counsel are essential. The constitutional right to counsel is not a slogan. It is one of the few barriers between a person and the full force of government power. Without zealous advocacy, writes our paper, innocent people can be railroaded. But zealous advocacy has a boundary. You cannot become a participant in crimes against the process. You cannot threaten witnesses. You cannot purchase silence through hidden channels. You cannot weaponize privilege as a shield for intimidation. If prosecutors can prove what they allege, then the issue isn't pressure corrupting a profession. It's criminality corrupting a case. As of this afternoon, here's where things stand. Marcus Webb, Daniel Harmon, and Priya Nakamura remain in federal custody awaiting arraignment. Bail hearings are scheduled for tomorrow morning in the same courthouse where they were arrested. Analysts expect the government to argue for detention, citing flight risk and the nature of the alleged crimes. Victor Ashworth's trial is suspended indefinitely. Judge Caldwell has scheduled a status conference for January 17th to address the mistrial motion and the question of new defense counsel. At least 4 prominent criminal defense attorneys have already publicly declined to take the case, citing conflicts and what they called toxic circumstances. The FBI is executing search warrants at Webb's law firm offices. Agents have been seen carrying boxes of documents and computer equipment from the Manhattan office throughout the afternoon. Additional warrants are reportedly pending for the firm's other offices. Witness 14 and associated family members are being relocated under emergency U.S. Marshals protection. Their testimony, originally scheduled for next week, will be rescheduled pending security assessments. The whistleblower who leaked the recording publicly, separate from the paralegal who allegedly made it, remains unidentified, and FBI officials have told reporters they are not currently treating the leak itself as criminal, though that determination could change. There's also the question of the leak itself, and it matters more than people think. Sources say investigators are not currently treating the public posting as a separate crime, but that determination can change quickly if they conclude the file was obtained unlawfully, distributed in coordination with any party to the case, or released with reckless disregard for a protected witness's safety. Judges also have tools to contain the fallout: stricter sealing protocols, aggressive enforcement of protective orders, and limits on public statements, while jury issues remain unresolved. And from Ashworth's perspective, every new development cuts 2 ways. He can argue the chaos has poisoned his ability to receive a fair trial, but the government can argue the chaos is evidence of guilt by obstruction. Courts sometimes appoint conflict-free interim counsel when a defendant is suddenly left without representation, especially when prior counsel become potential witnesses or targets. That's how messy this is. It's not just a trial on pause. It's a case restructuring itself in real time around an alleged betrayal of the court's basic rules. Keep a close eye on the status conference. Judge Caldwell's decisions regarding new counsel, evidence taint, privilege, and the prosecution's ability to use defense team communications will shape everything that follows. The next 72 hours will determine whether this case can continue at all, whether it collapses under the weight of its own corruption, or whether it expands into a larger conspiracy investigation with more targets and more arrests. A protected witness is in hiding. 3 defense attorneys are in custody. A major corruption trial is in chaos. And the legal system is confronting a nightmare scenario. What happens when the officers of the court are the ones accused of criminally obstructing justice? Subscribe for updates.